We have more for your ears only. I'm Eddie Robinson.
I'm David Alpern with this quote from the news. Before throwing Einstein on the bonfire, you would like to see an independent experiment. That was John Ellis, a theorist for the European Center for Nuclear Research, questioning new findings that neutrinos could move faster than the speed of light, which Albert Einstein theorized was the absolute cosmic speed limit. Now this.
He said, the incident that night was not my fault. I did not have a gun. And to the McPhail family, he said, of course, I did not personally kill your son, father, and brother. I am innocent.
Eyewitness accounts of Troy Davis's death by lethal injection were read to the media last week, minutes after it took place, and more than 20 years after Davis was convicted of shooting off-duty Georgia police officer Mark McPhail to death. The execution ended a huge campaign in Davis's behalf by the Pope, former President Jimmy Carter, and other VIPs, and more than 600,000 petition signers on paper and online, based largely on 7 of 9 original witnesses in the case recanting in sworn affidavits, some claiming police pressure. But the case also added momentum to the growing debate over eyewitness testimony itself and the need for new procedures to make fairer use of it.
The New Jersey Supreme Court last month became the first in the U.S. to issue strict new rules on the admissibility of witness identification based on recent studies showing that eyewitness testimony, especially based on police lineups, can be seriously flawed and may have sent armies of innocent people to jail or worse. For more on this reversal of what once was considered best evidence, for your ears only, we're joined by Brandon Garrett, a law professor at the University of Virginia and author of the book Convicting the Innocent, Where Criminal Prosecutions Go Wrong, published by Harvard University Press. Professor Garrett, welcome to our program.
Thanks for having me.
What are the most important findings of those recent studies on eyewitness testimony on which the New Jersey court based its ruling?
Well, it's not even recent. We've known about this research for decades now. It's just taken a long time for law enforcement to listen and for judges to listen. But we've known since some early studies in the 70s, more in the 80s, even more in the 90s, all confirming each other, this massive body of psychological research that eyewitness memory is malleable. So a lineup isn't just a test. The test can itself change someone's memory of a face they saw if the lineup isn't done right.
To what new police procedures does the New Jersey ruling seem to be leading, and how far beyond New Jersey itself?
Well, New Jersey actually already had good lineup procedures in place, and the key reform is to make sure that the lineup is done double-blind. And we've probably heard the idea of double-blind experiments for drugs and things like that. Scientists do blind experiments all the time so that the person doing the study doesn't bias the result. And so the key with an eyewitness procedure is that the officer doing the lineup doesn't know which person is the suspect, because it's really, really easy for them, even unconsciously, to give cues which might tip someone off and lead them to make a mistake. And New Jersey has done that for a long time. Most states do not. And so that's crucial reform number one. New Jersey has now gone the next step and said, look, we already have good lineups in place. Let's make sure that there's a system for carefully evaluating eyewitness IDs if they come into the courtroom.
And what about instructions from the judge himself to jurors?
Well, so that's what they offer. So a lot of jurisdictions around the country have wondered, well, okay, we need to get lineups right, but what will happen if something goes wrong and police don't do the double-blind lineup or they make suggestions to the eyewitness? Does that mean the ID is going to get thrown out? Under current law, the rules are pretty flexible. They rarely get thrown out. And New Jersey has actually left things flexible, but what they encourage judges to do is to educate the jurors and explain the social science, explain the correct factors to them so that they know what to think of it. Because what the jurors often see is an eyewitness who is incredibly confident, sure that this is the suspect, but they might not have been so sure when they first looked at the lineup. And that's what I saw when I looked at all these cases of people who are innocent, freed by DNA. The eyewitnesses at their original trials were usually highly confident, and we now know they were wrong.
Are there racial factors involved in erroneous eyewitness identifications, more errors when a witness and suspect are of different races?
Absolutely. Many of the cases that I looked at, these innocence cases where DNA freed someone, were cases that were cross-race identifications, where it was often a white victim and a black suspect. But what the studies have shown is that either way you're doing it, people just have much more difficulty recognizing faces of another race. And in fact, they actually have difficulty recognizing faces of another age, too. Our minds sort of reconstruct things in a way that's familiar to us. And so, juries have to be aware of that it's harder for someone to remember. It's also harder if you see something in the dark, if you're looking at a weapon and not at the face. And an eyewitness memory degrades rapidly over time, so it's very important to do lineups as quickly as possible.
Changes come hard to people, especially people used to unquestioned authority like the police. What do we know about early police reactions to the new doubt about eyewitness testimony, the New Jersey ruling, revised procedures to make it more accurate?
Well, I was on a radio show with someone from the Attorney General's office in New Jersey, and they said, look, we've had good lineups in place for 10 years now. It hasn't been hard to implement them. What we're going to get now is more careful jury instructions. It's not going to be hard to adapt to that. More and more jurisdictions have really been hit hard because of these DNA cases. Out of nowhere, these cases that everyone thought were open and shut cases, all of a sudden the DNA testing is done, and it turns out an innocent person went to prison. And often, in 3/4 of those cases, it was an eyewitness. Sometimes 2, 3, 4, or 5 eyewitnesses who all got it wrong. And so I think those cases have really brought it home to police that they need to get these procedures right.
The issue of witness reliability will come up again on November 2nd when the U.S. Supreme Court hears the case of Barry and Perry versus the state of New Hampshire, in which a single witness identification was central to Perry's conviction for robbing a car in 2008. Will the New Jersey ruling and underlying studies play a role in that argument?
I don't think so. The case there raises a pretty narrow issue. There, the police arguably weren't even trying to do an identification procedure at all. They weren't doing a lineup. It doesn't bring up, should police be doing double-blind lineups? That's one of the most crucial reforms there. The police ran into someone who saw someone messing around with cars in a parking lot. They told a suspect to wait there while they went up to get the witness. The witness looks out the window and sees the guy standing there by the police and says, that's it. So they weren't trying to orchestrate an identification. On the other hand, the police were there. They told the guy to stand there next to police. So there's a question about whether there's sort of state action to justify application of constitutional rights. So it's a technical case. I don't think it's going to raise issues like in New Jersey. And so for now, this New Jersey decision is really the national model that states are going to look at.
Brandon L. Garrett is a law professor at the University of Virginia and the author of the book Convicting the Innocent, Where Criminal Prosecutions Go Wrong, published by Harvard University Press.
Quote from the news, I don't know how they could paint such a rosy picture to us and declare bankruptcy 5 weeks later. That was Colorado Congresswoman Diana DeJette, top Democrat on the Oversight and Investigations panel of the House Energy and Commerce Committee, following Fifth Amendment refusals to testify by 2 Solyndra solar energy officials about reportedly improper applications, reporting, and approval of $500 million in Energy Department loan guarantees.
Next, super devotion to a superhero, for your ears only.